we have 3 different models that we're going to share. And senior peacemaker JoAnn Battise is from Alabama, Coushatta.
Okay.
And she's a former tribal administrator and chairwoman, and has served on the tribal council for many years. And I like what she said last time. She knows the family dynamics of her tribe. And I think that's an asset in terms of her leading the Peacemaker court. And Nora Antoine is from the academic setting, but served as a mediator for court, schools, and really brought, I thought, an Indianness to the mediation setting. And I think that's an important piece. And as I listened to her, I really learned a lot, because I had kind of shut down on mediation because I got stuck on this thing of very formal mediation and you have to be a neutral. And I thought that is so counter to tribal, because we all pretty much know each other. And so with her academic background and working on the grassroots level, I think this provided another option. And I like what she said, the entry. There's other ways to enter into this as tribal nations. And then Kevin Briscoe, of course, is the Chief Justice for Mississippi Band of Choctaw, but he has been in on the ground level of peacemaking with the youth court, and then having to take over the Peacemaker session, Peacemaker court for the former Peacemaker who we're honoring as Niger, because she has since passed. And he has a full spectrum of peacemaking, all different models that have been tailored to meet the unique needs of their respective tribes and the people they serve. So we're going to start with JoAnn, then move to Nora, then end with Chief Justice, and it worked really well with a question and answer after each presenter, so we're kind of on their subject matter. Yes.
I'm JoAnn Battise. I'm the senior peacemaker for the Choctaw tribe. I've been doing this line of work for 5 years now, and I'm glad to see that the rest of the peacemakers have joined this session this afternoon. There's 4 of us. The other 3 are full-time tribal employees. So whenever we have a meeting, Peacemakers meeting, or a review day, or our hearing days, they take leave from their regular jobs and perform as peacemakers. They each bring different values to our court. And I think what works best is what they bring forth. We have Janie Ryan-Smith, who is our education director, and she has the world experience. She's traveled, learned a lot about different cultures. And we have Julie Williams, who is our youngest peacemaker, and she has worked in social services and now works in human resources. So she understands what Peacemaker does without the training that we went through in the beginning. And there's one other Peacemaker who's not here. She is the daycare director, and she brings the nurturing factor to the Peacemaker court. So we all work together. I I, as senior peacemaker, do the emergency cases as they come in whenever it happens. And having served as a tribal administrator for the tribe for years and years, I also served on the tribal council and have served as general manager for a tribe in the Northwest, ran my own business. So whenever there's an emergency occurs on the reservation, well then I come in and handle it. In extreme cases, we have to conduct a hearing within 72 hours of the incident. But the tribal court is an essential component of tribal sovereignty. And our tribal council finally realized that. We've needed a court for our tribe for years and years. And in 2007, we received a grant, a court improvement grant, to start developing a court system. In 2009, we opened our doors, and our landmark case was an adoption case. This case had been in limbo with the state for nearly 9 years. The child was growing and growing older, and when the mother filed in our court, we were able to proceed with the adoption. In 2011, our court was designated as a model trial court. In 2013, I was appointed to a 3-year term with the State of Texas Supreme Court Commissioner for Families and Children. And in 2014, we're going into our 5th year. So it seems like every other year something good happens to our court. And we're waiting to see what's going to happen in 2015. Like I said before, maybe somebody will win the lottery and build us a new building. But with that history, our Peacemaker Court for the Alabama Choctaw Tribe has been uniquely theirs. There is no other court. We started with the Peacemaker Court. And the only support we had was from the Tribal Council, Social Services, the Peacemakers. We were considered a kangaroo court from the beginning because our tribal people did not understand what a Peacemaker court was. We have handled, in the 5 years that we've been in session, we have handled all types of cases. We have several codes that govern us. The first being the Constitution. We have a Children's Code. We have a Peacemaker Code. We have a Children's Code and Indian Child Welfare. Our Children's Code is much stronger than Indian Child Welfare, so we use that a lot. In the event that we do not find what we need to do to resolve a case from these codes, we rely on our customary and traditional laws. We speak our language in our sessions. Sometimes there are elders in there who are supporting the parties. They don't understand very well, what we're talking about, so we resort to using our language. That's the culture. That is our culture. In the area that we are in, we're isolated from big cities. I think we're 100 miles northeast of Houston. But we also work with the local people, Polk County and Tyler County. One is to our west, the other one is to the east of us. Our criminal cases are handled in Polk County. We do not handle anything in our peacemaker court that is adversarial, but we do protect a child if a child is involved. We vacated to the civil court now, which opened its doors 2 years after we were in operation. There's a section in our children's code that gives us the authority to do what is necessary to resolve an issue. And we relied on that. We still do. There is no question that our peacemaker court is good for our community. For years, we have told the tribal council we're doing the best we can. We are not lawyers. Attorneys are not involved in our peacemaker court. It's tribal people. And that's uniquely how that shine. For years, we've told the council we've done the best we can, but we're telling them now we're doing what's right for our community. Because we're stronger, we are more experienced, we have built our credibility, we have MOUs with local enforcement agencies. We have MOUs with CPS, also with the state of Texas. The last 2 years, we've partnered with the state of Texas, and they have supported what we do as peacemakers. The last 2 years, the state of Texas have come in and supported the symposium that we put together every year. That's where the learning process of what peacemaking is all about comes, because we invite speakers from across the nation. And from that, the concept has gone on. The concept of peacemaker has gone on to our local judges in order to alleviate the overcrowdedness of jails. They're using the concept of peacemaking with their felons. We try to keep our people out of jail. They come to our peacemaker and find out that they can work it through. We're not negotiators or mediators. We're peacemakers. We listen. We listen to what they have an issue with. And eventually they get to the point where they get comfortable, they learn to talk, they come out and talk. They're not embarrassed. Sometimes it's emotional, sometimes it's anger exhibited, but they respect the courtroom rules. That's to respect the judge, respect the courtroom, respect others. We do not use a microphone. We use a basket made by an elder. This basket is made with pine needles, knitted together with raffia. It's full of blessings. It's a powerful tool. And no one in the court before the judges can jump up and down or talk against one another or interrupt one another unless they have the basket in their hand. If there are 12 people on one case and they all want to talk, we give them time to talk. They take 1/12 of the hour. And it has worked out well. Everybody expresses their opinion. But the two parties involved come to a consensus. They have to come to a consensus. If they don't reach an agreement the first time, we bring them back. There's no appeals process in our system. They have to come to a consensus. In some cases, they agreed to go to anger management. They've agreed to seek rehabilitation. They seek drug counseling, alcohol abuse counseling, domestic issues. they're the ones that want to do this. And what we do as peacemakers is generate questions where they will get to a point of being comfortable and talking about their issues. When they come to an agreement, we call that reaching a consensus. We have a minute agreement that they sign off on according to what they agreed to do. And then we transfer that information from the minute agreement to a official order. And they must comply with it. Each party receives a copy. But there are cases where we've had to seek placement with children where children are involved. Extended families have stepped up to the plate. They take the children while we work with the parents. The reunification of family is our ultimate goal. We may separate the family for the time being, but if they agree to do this and that and the other, we give them the time to do it, and they comply with what they agreed to do. If they don't, then we cite them contempt. They do community service. The peacemakers understand the people. And in the other session, I said it was easy for me because I've served in such capacity as tribal administrator, as tribal council, running my own business, or dealing with people on the reservation. And it's easy to be a peacemaker because I understand family dynamics. And you have to know that. If one party filed a petition in our tribal court with the court clerk, and yet they were going at each other at the local bar, Walmart, or wherever, they don't bring that into our hearings. We deal with what is on the petition, and they work it out. So we learn to listen. We don't interfere with their thoughts. They're the ones that talk about it. They want to talk about it, and sometimes it gets emotional. We have courtroom procedures that they follow, and they respect that. We expect them to respect that. We work with the police department. They provide bailiff for us during our sessions. We've never had to use bailiff to escort a client out. It's always out of respect for the court. They're there for a reason. They want to earn it out, come to an agreement, and follow through. We also work with Social Services Department. They are our first responders for situations that come up during the day, in the evening, especially on weekends. And we have 72 hours to conduct a hearing and do what is necessary to protect the child when the child is involved. Once the parents agree to receive counseling of any sort, we help them get there. We provide the resources for them. And if and we do a lot of kinship placements, and we help these people who stepped up to the plate to take a child while the parents are going through growing pains, as we call it. We help the person who took the child in with a small subsidy until such time that the parents are reunited, they have completed, and the child comes back to their home. We had a very successful case recently where there were drugs involved. Children were running in the area real late at night trying to find help for their parents, the oldest one anyway. A sister stepped up to take the children. The parents decided they needed help. And just recently we closed the case because they completed everything they agreed to. Children were happy to come home. And as far as we know, they've started attending church. They're doing activities with their children, and a happy family. We see a happy family after a session in court. And we get the satisfaction of knowing that we were there to help them. Otherwise, they'd be taking their situation into Polk County through their court system. We find that the Peacemakers Court is very effective, cost-effective for our people. We do child support issues, and we know if they are tribal employees, we know how much they make. So we can't ask them any more than what they can afford. But the amount of child support is comparable to what the state of Texas imposes on other families. We have built credibility with the state of Texas through MOUs. We've partnered with them, and they are eager to come out and help us. We've been invited to other symposiums to learn what they do with their own court system. But in the beginning, the Peacemaker Court for the Alabama Coushatta was the only court. We did not have a civil court. We did not have a criminal court, nor did we have an appeals court. But those are dreams on the back burner. They're working, our tribal council and their general council are working on these. They're attempting to strengthen the codes that we work with. But the one thing that they cannot do is strengthen the traditional values, the customary law, and the language that we speak. Those are values that's been handed down generation to generation, and they will continue. So for the moment, what we have is good for our community. We're a small tribe. I think about 1,200 members. Half of them live on the reservation, others live elsewhere. We now have built our court system to a point where other factors are coming in now, like our Title 4E, Title 4D. We have our own Child and Support Enforcement Division, which is the newest thing that's happened in our system. We find that whenever there's a situation off reservation, well then as serving as commissioner with the state Supreme Court, I get involved with that. And we've had cases from West Texas, we've had cases in Southeast, I believe. They are tribal members, and we help them as well. So we have a long arm. We believe in self-determination. We want to become self-sufficient, but most of all, we want to continue helping our tribal people. So in the end, we know that Peacemakers have done a valuable job. We know that this will continue on. Because what we did is take a concept, formalize it, and it has worked well for us. So I know, and the rest of the Peacemakers can tell you, that what we do as Peacemakers are the right thing for our tribal people. They called us a kangaroo court in the beginning, but we've built our credibility to such that they respect the court now. They do not want to go into civil court because the civil court judge can enforce his orders. The civil court judge will take a case, and if he thinks that it can be resolved in Peacemaker court, he has that transferability. The same thing with us. In an adversarial emergency issue, we'll protect the child and vacate the case to civil court. So we work as a team, social services, bailiff from the police department, Peacemakers, our court clerk, civil judge. And I know that this is something that Tribal Council didn't envision. In 2009, they said they set out a budget for us, hired the Peacemakers, and said, go with it. We did not get any directions, except for Cheryl Fairbanks, have made our court into what it is now. And I know that people cannot do without Peacemaker Court today. So with that, I'll end the my role as a senior peacemaker is to take these cases as they come in and assign them to any one of the peacemakers. We've had one peacemaker that refused herself quite frequently because she belongs to a big family. And when those family cases come in, she can't hear it. But we work together. We review the cases before our hearings the next day. And after each hearing, we go into the conference room and review what just happened. There are times when we've had to call back families because they never settled the issue. So it's a good thing for us. It's not that we're experts as peacemakers, but what we've done so far as peacemakers has been good for our community. And our thanks go to Cheryl Fairbanks. She's worked with us for years to get this started. She's worked with the Choctaws. She's worked with the Tangas. And we've had other tribes come visit our court while we're in session. And sometimes we provide advice to others as they move forward to create a court system of their own. We're there to help. That reunification is our ultimate goal as peacemakers. We've not lost a child. We're always there to help. So that's the story at the Alabama Coushatta Reservation. It's been a long, hard job putting together a court system that will meet all the needs in the community. We do receive training whenever we can, and we use that training to strengthen the knowledge that we have. So it is a workable solution. Peacemaking is a workable solution for all of us. It doesn't have to involve attorneys and judges. And as I mentioned, there's no appeals process. We just bring them back into court. They talk about their issues. They reach a consensus. They agree to an interim agreement, and we transfer the information to a formal order, and that's what they comply with. So to us, it's an easy process. The problems are the ones that's hard. Any questions? Yes.
Do you have your own police force, or how do you enforce your rulings? Like,
We don't enforce our agreements. We
Please.
have no appeals process.
if you assign someone to community service and they don't do it, you said it's contempt. So how do you enforce that contempt order?
They do community service.
Well, they do it regardless.
They do community service, but there's one case where we cited contempt for non-show, but he was in jail at the time, so we understood the situation. But we've been able to work with the family. But the cases that our social services handle are not always filed in our court. They can settle an agreement with family competency. And at that level, if and when they cannot reach an agreement, that's when it's filed in our court. Any others? Thank you very much.
I just, somehow we need to lighten the situation sometimes, and the Peacemakers are Julie, Jean, Janie, and JoAnn, and we call them the 4 J's. Next, we'll hear from Nora.
Speaking of lightening the mood, this is the picture that I've been looking at. My newest Coushatta, born October 1st. So, quite inspirational. Her name's Jackson. But I wanted to talk briefly about, the rationale, the reason for peacemaking. And I think to preface my part of the conversation here, because I think, seeing Jackson's picture and all of you involved in your communities, we have a vested interest in what happens there, not just for ourselves, because I think all of us as professionals, we do okay. We can create a living for ourselves and function pretty. The notion that we are a collective, that we are a people concerned about each other. And I think that is the basic premise behind peacemaking, is that we want to look out for others as best we can without upsurting their sense of obligation and accountability. So given the diversity of all our tribal nations, and on this continuum of peacemaking, not all tribal nations are at the same place all the time. And in our particular case, I have had many robust discussions with advisory committee members to the NARC Indigenous Peacemaking Initiative, because it always sounded to me like some of my colleagues were from another made-up utopic society. We're going to go in, we're going to offer prayers, people are going to be compliant, they're going to want to change, that, people are happy, and peacemaking is just this other world kind of experience. And I was always, I wouldn't say the devil's advocate, but a realist in knowing my tribal community where there are just so many challenges. We're about 40,000 tribal members. Most live on the reservation. You know, high unemployment, all these other kinds of social ills and problems. And I hope that someday we get to peacemaking. But until then, we have to face reality and think of ways to enter into managing our conflict as best we can. And I love how you said that. We're not perfect, we're not the experts, but we do the best we can. And I think that is a major takeaway component for you all. It certainly was for me, because many years ago, being new to the peacemaking process, I certainly wasn't an expert, but at home they said, well, you're the best we got, so you do it. So what that meant for me was that figuring out how to take this really beautiful, nearly utopic process of creating healing in a circle using some type of talking piece. In order to get to that point, I had to backpedal a little bit and create what I could, how I could. And in the case of Rosebud and other communities that are very new to peacemaking, you may not enter that peacemaking door. Maybe that's not an option for you. But perhaps you can enter into mediation, let's say. And that is the door that works for us at Rosebud presently. That doesn't mean that it has to be this very Western, very structured process. It can be Indianized, if you will. It can be culturalized. It can be spiritualized. You can take what you learn as a mediator to bring space, to bring safety, to bring a sense of value to conflicting parties who may not have felt value, certainly towards each other. So the way that this happens in Rosebud is that our tribal code allows for the judge to integrate cultural practice into their work. And so to me, what that means is that they have the latitude to create and to invoke peacemaking practices from their judge in their black robe and gavel in hand. They have the latitude to do that. There has been in recent years some code updates to strengthen that. And I think that given the seniority of many of our tribal judges, not just at Rosebud but other places, and being a long-term faculty member, you kind of go with what you know. And I think from that perspective, I think judges go with what they know, what their comfort level is. And you refer back to all the case law that's been written before you in order to do your business. So I think that there is going to come a tipping point. There's a tipping point that's coming where judges in tribal courts are going to feel like there's more inertia, more momentum for invoking peacemaking. And some are farther along, certainly, than others. And primarily, from where I sit, it's a matter of those that have been given resources to do more innovative kind of work. In the case of Rosebud, what they do primarily is they use mediators. As a mediator, they'll call me. The judge hears the case and says, would you consider mediation? Now imagine if you're the conflict parties, that's a pretty frightening process. earlier in the session this morning, I talked about how tribal courts have become the surrogate grandparent in effect. So I think so many tribal members have been disempowered in many different ways so that they don't feel like they can maybe create their own solutions. So part of what I think I am charged with is not just balancing power, but creating an atmosphere when we mediate to offer them guidance and assistance in talking through very difficult circumstances. So the room is set up, for example, if I have a smudge pot, perhaps I smudge prior to the session. The parties come in, some reluctantly, and unlike your guests, sometimes they are served 2 and 3 times before they finally make it into court. The agreement that they eventually forge is one that is in their language. The judge is the person who, after the fact, looks at that agreement, and there's a holding time, 6 weeks, 3 months, to assure that the parties are going to stick by their agreement. To my knowledge, there's very few that retract on their agreement, which is a good thing, and that's the power of the peacemaking or mediation process, because the likelihood of them going back on what their agreement said is lessened because they're the ones who forged that agreement, so they work to get there. And oftentimes there's some benefit, there's no fine, or the fine is minimized, or the penalty is waived, some kind of incentive, so to speak. The evolution of the mediation process, again, thinking about this as a continuum, has been such that sometimes the prosecutors have said to their judges, I don't want to refer any cases to mediation because it's going to lessen my docket. Which is really quite ironic because tribal courts are so inundated with cases. So I think that there's a lot of education that needs to go on from judges on down to his staff about your resolve and your invitation for people to participate. I know in terms of Rosebud, there was a new public defender who came from the county over, a white attorney, and I was talking to her one time, and she said she sees more cases in 15 minutes at Rosebud than she would all week in county court. So that's the rigorous cycle of cases in tribal court, and perhaps you already know that. So I just wanted to be sure that people had a sense that not everybody can enter into peacemaking immediately. At Rosebud, it's a very gradual process, despite the fact that the tribal judge is a strong component. He's still faced with the reality of not having enough dollars to support peacemaking or mediation through the court. And I think that's a national, issue, that there are very few dollars set aside for peacemaking. I think it's changing because the rates of incarceration and whatnot are just so astronomical. So in terms of the Rosebud, or a model from Rosebud, they do external contracts. I help a little, but they use other mediators to come in when various cases warrant what they consider a good case for. They call it peacemaking, but really it's mediation. And the difference, as I understand peacemaking, is that peacemaking involves more than just the two conflicting parties. It could involve the family, it's a talking circle, it's spiritually based. And like I said, Rosebud is, we're working towards that, but we really aren't there yet. The shortest mediation that I've been involved with at Rosebud was 15 minutes, the longest, 6 hours. And so it really is an investment in time. And the way that it's done there, because sometimes it's so difficult to get parties in the first time, we keep them and go through it until they resolve. So perhaps sometimes it's just a matter of wearing them out, I don't know. But normally the end result is such that they are pretty, I think, sincere when they're done and forge an agreement. Any questions so far? Must be all the smoke.
I got a question. You said your shortest was 15 and then your longest was 6 hours. Was that in the day, or is that the whole to where we determined?
That was one session, one mediation session. Yeah.
How many sessions usually does it take, or there's unlimited amount until you get that resolution?
Well, I think the more complicated sessions we've had scheduled at different times, but by and large, most are completed in one sit-down session. Yeah. And that's because, it's the cost for them to come in. Often that's a barrier. And, I think that just in terms of, a practical barrier, what we don't do, and again, it's at Rosebud, it's such a fledgling kind of operation that we don't have like the support, that wraparound support that you have there, and it's very piecemeal. So because of that, I think that it's so difficult to get parties there the first time that we just try to, have them work hard and complete the process in that one session. So the model of tribal court, although isn't ideal, we are in the process. I think, like we're on first base as opposed to other courts that are on second or third base. Right? So that's one model of peacemaking or mediation that I can share. What has grown from that is at the local school districts, and then, I often have a chance to go and speak with other high school classes and other college classes and communities. And what has happened at one local school district after doing some work with teachers is they implemented a mediation process into their grievance procedure for adults, which is good for the district because then instead of a conflict growing as conflicts are prone to do, they could minimize it by pulling in a mediator earlier than later into the process. Before, people used to go to the board, and for any of you who've ever been on the board, you know how unwieldy personnel issues can be. So that's another example of how mediation, I think, can work. And even though it doesn't sound like a really big event, it really has helped this particular school district because they also integrate different sessions for their kids. And by kids, I mean like junior high and high school. And one of the things that has worked well at Rosebud in terms of creating mediation programs, they have the peer mediation, but in some of our communities, there's such a high gang rate that kids are really reluctant to engage in peer mediation because of the obvious factors. And one of the things that one particular school district did in recognizing that is they started bringing in parents of conflicting parties, and the parents then would have, it's almost like a pre-conference, and then as a requirement prior to the girls mediating. So that has worked really well for any of you who are working with youth-related. Oftentimes, I know at Rosebud, they had a situation where if the zero tolerance policy, they would immediately call the tribal police, they would remove the youth, and then send them out to the JDC. So by integrating a mediation program into the school district has helped thwart that, because none of us want to see our children go through that system if they don't have to. So, I wanted to offer those examples of different models in order to encourage more participation from your educational systems. I don't really feel like Judge Marshall, I really feel like peacemaking does belong in the community, but how does it get there? And I think a good way for peacemaking to get in the community is through our educational systems, from Head Start on up to higher ed. So, but I'm going to talk about that in another session. Thank you.
All right, and next up we have Judge Kevin Briscoe from the Mississippi Band of Choctaw.
They've only given me 5 minutes, so I'm going to try to get it all.
You wanted it that way, so stop.
Thank you and good afternoon. Again, my name is Kevin Briscoe. I serve as Chief Justice of the Mississippi Band of Choctaw Indians. Newly appointed to this position a year and a half ago by our first female chief, Chief Phyllis Anderson. And before that, I've been through 2 other administrations. Chief Philip Martin, who passed away during his term, 28th term. And then Miko Beasley Denson the year before, and then Chief Anderson who appointed me as Chief Justice a year and a half ago. It's my pleasure to be here and talk before you about peacemaking. As a Chief Justice, I had to give up a lot of my duties as senior youth court judge. During the youth court position, I held many hats. I was the youth peacemaker judge. I was the teen court judge. I was the youth healing and wellness courts judge. I was the standing judge for the adult healing and wellness, and also, like my colleague, Judge Peacemaker Battise, we also have the recognition that we are a model court. We got established in 2012 as a model court, and also I serve on the Commission for Children's Justice in Mississippi. So we have a little in common with the Alabama Coushatta out of Texas. I'm going to give a little formal interview process as far as what the courts that we go through. In our language, our court is Itikane Igbi, which means peacemaking court. The Choctaw Tribal Court has 4 systems, which is our civil, criminal, youth, peacemaker, and our Supreme Court. In our courts, we have myself as Chief Justice, 2 associate justices. Civil court, we have a senior and an associate. Criminal, we have a senior and associate. Youth court, we downgraded because of the amount of cases, I guess, unless they did a good job to where we were able just to accumulate 1 judge for that area, and then peacemaker too. So each position, most have associate, but with our courts, our criminal court judges and our civil court judges are able to go in our youth court and perform them duties, but not as far as the peacemaker judge, but as far as the civil court, because our civil court judges are non-tribal. So the criminal court judge, who is a member of the tribe, and our youth court judge, who's also a member of the tribe, can go into our peacemaking. And right now we are going through a process the senior peacemaker judge, again, was only one judge. She passed away in June, so we are without a peacemaker until our chief appoints the next peacemaker. I'm hoping within the next 2 or 3 weeks that we will get that. But again, I appreciate our youth court judge and our criminal court judge for standing in, and right now doing a good job as far as handling the cases that we have existing in Peacemaker Court. The purpose of the Choctaw Indigenous Court is known as Peacemaking Court, to provide a forum for the use of traditional and Choctaw methods of opposing parties to resolve disputes in a fair, formal, and inexpensive manner. Any ambiguity in the Indigenous Code shall be construed to carry out its purpose of encouraging traditional Mississippi Choctaw Indians methods to dispute resolution without formal proceedings. Again, with our Indigenous Court, our courts do not allow attorneys in there. Once the court is transferred from formal court to the Peacemaking Court, everything is resolved unless they do not resolve, they kick it back up where the court setting was stayed, and then it can continue on at that time. But during this whole process, it's between both parties. If they want to bring in family or relatives or friends that were involved in this case, they can do that. But mostly it's usually the victim and the aggressor in this matter that come before the Indigenous Court. Our vision for the Indigenous Court is to provide a formal whereby all individuals who encounter conflict with others may be able to find peaceful resolutions in the conflict and end what may become a violent confrontation or simple as the first situation. Also, it is the vision of the peacemaking to bring families back together when adversity among family members' homes have been broken. It's the goal of the peacemaker to help find the resolution between Choctaw individuals who are having legal difficulties because of conflict and with other individuals. It is the peacemaking's goal to save as many Choctaw families as possible from breaking up. The peacemaking aims to accomplish these goals and nurture the relationships where peace is established as part of their relationships. There are questions that come before the Indigenous Court, and it asks, one is, what kind of cases can be transferred to Peacemaking Court? Court cases that may be able to come to Peacemaking Court is domestic, child custody, domestic violence, probate, trespass, property disputes, commercial transactions, employer dispute, IDR, which is inter-dispute resolutions within the companies and organization, tribes, and etc. Also, another question is, can youth court cases be transferred to Peacemaking Court? And at first, when we first started, there was just that frame of Peacemaking Court. And everybody that came to Peacemaking Court was an adult. And so, when I came aboard, it was because one of our judges got sick and we didn't know what time frame she was going to come back in and cover cases. So our Chief Justice at that time said, you've been through the peacemaking process and everything, and you've worked with our youth as peacemaking. I think you can work with the adults. So once I got in, I thought, there was like 7 cases. It turned out there was 27 cases that I figured out. So it was maybe within, she was out November to February, so I situated my schedule to fit where I could work with her from February to July, and I think that's where I ended all cases. But she came back within that time period. But it got me to working with adults, and there's a whole different separation as far as from youth and adult situations, because more or less it's a learning process for, to me, youth. Youth are growing, they don't have that frame of mind, but to know right from wrong. But as far as adults, I think they should know, but I think you got to give them what we call a little talking to, get back on where they need as far as responsibilities as adults. So I was able to go in and help with that court, and like I said, it helped me grow as a person too. Cases that we also consider that we work with is, like I said, Peacemaking Court, or we can transfer to Teen Court, or Youth Healing and Wellness Court, and our newest, which we have a grant for, which is called Osapa Amisology, which is the Little Healing Garden. And this program helps our youth understand the history of our people, where our people were farmers. And so it establishes how to grow or prepare for a garden, how to nurture it, and then the fruits, come out. Because most of the kids in our communities think that all the fruits or vegetables come from Walmart. They didn't know that it grew from the ground up and everything. So it taught them a lot, and it was funny too, because a lot of the kids who graduated from the program, I didn't wear my medallion here. I took it out at lunch, but going through the process, we honored them. We made sure that we gave them, direction in life, and so we were kind of like, their brothers and sisters, and we always did activities on the weekends with them, and made sure that they were somebody. They were always, these kids were, I say, loners, where nobody, they weren't part of organizations, they weren't part of groups or teams or anything like that. So they were left alone, but they felt once they got in this program, they were a part of something. And then these kids that found out that they were doing all these things, and at the end they got this pretty medallion, they were wanting to get in. So they started committing crimes to get into the program. So that's not the way to get in. If you want help, we can work with you to come in and help as far as an honorary person that come in and participate, but more or less it's for those at-risk kids that we're working with within this program. Also, we were last year we were given the opportunity to apply for a grant, which is the JDAI grant, which is Juvenile Detention Alternative Initiative Program, and it's a way of deterring kids from coming or working with the courts so they won't go to jail. And like I say, we are newly established, but I think it's still newly, which is in 2007. We built a multi-million-dollar facility for house our adult, male, female, and youth and female minors. And like I said, I kept, whenever this program was established, the jails were primarily filled, and we could have up to, I believe, 8 juveniles. If we double it, it was 16, and then vice versa, same as our youth girls. So, but when this program came along, it helped me understand that we're not really doing anything in there, but just staying there, and we need to get them out into the communities and work with our elders or different things like that. So there's alternative things within this program that help our youth instead of staying in detention. Rules of peacemaking. I know I'm probably going over things that my co-presenters have already went over, but there's a rules within our Intikana Igby Court, which is our first. It's open with a prayer. Prayer is a very meaningful thing to us as far as to make sure that we come in with a clear heart, that we're open to listening to disputes or conversations that you can't have at home. This helps us to guide us in a friendly manner. Also, there's introductions to make sure that we all know what parties are within the realm. Statements of issues, and Peacemaker Battise talked about the issues that you sit on so you don't bring outside things that sort of hamper within why they came to court. We sort of stick on the issues that are before us. Also, we do make sure that everybody has a chance to speak, and just like Peacemaker Battise, we do have our traditional swamp cane basket that once that person has, that's the only person at that time can talk. You'll get your chance as long as the basket continues to go around. And everybody must participate fully. Also tough on the issues, but gentle on the person. Because like I said, they talk about you don't know what that person's going through. And I really got to feel of that when I went to a house, and I was always on the kid. I mean, I was just, why are you coming to court? Why do you have to be so bad? And everything. When I went back and looked at his home life, I mean, I walked in that house and I didn't understand how people could live like that. I mean, but it was more or less he lived in filth. There was clothes all over. There was puppy dogs, and there was different things around the house. And I knew how he felt then, because I mean, he went to a home where there's not the home life that he wanted. He wanted to come home and have a clean house, and he didn't ever want to stay home. He would just want to go out to his friend's house, and there was a stipulation under his court order that he get permission from the mother and father to go out somewhere, but no, he would do things on his own. And it really just touched my heart that, you know, unless you walked in that person's shoes or have been a part, don't start, I guess, blaming or making accusations. And like I said, when I saw that, I felt like I knew what he was going through. So like I say, I was gentle on the person, but you know, it had taken me a while to figure it out and go see his home life. Also, there's also a chance to learn. Again, coming from the youth peacemaker court and then going to the adult was two different scenarios. Respect the speaker, be a good listener. Only one person talks at a time and others will sit there and think. Also, listening is more important than talking. Also, there's silence, and silence. During that silence, and I wondered about that when we drew this up, is sometimes you got to give yourself at least 2 to 3 minutes to sit there and bring it all in, because you know you can sit there and you can already, like sometimes I go far away when somebody's talking if I don't feel like it's relevant to me, and then I just go back into what you say or so. So you have to really pay attention, you know, to know what's going on. And I know some of the litigants that came through the court would just sit there and just roll their eyes, you know, and it's like, hold on, and I have to stop and say, you got to listen to her, look into her eyes or so. Because, you know, you can wander off, you know, you think you're always right, but you're not really always right. You need to listen to that person and understand what they're coming through. Because like I said, the problem may be minute, but unless you understand, because I've had a lot of cases with adults where it was more or less, you know, they didn't go back to saying, I love you, or thank you for a good meal, thank you for washing my clothes, different things like that. They just got away from each other, and that's all she wanted him to continue. When they started dating, that things mean a lot, and I've noticed that with women, you know, birthdays, anniversaries, things you might, as a man, we don't think about that, you know, and like, man, why she was so mad today, you know, it's our anniversary, you forgot, you know, so, I mean, there's a lot of meaning to that, you know, but it's two different worlds there, but guys, remember all the things now, little things do count. Also, discussion and apologies for forgiveness, and during the process there, when you're going through the sessions, it's consensus building, and apologies are given, and forgiveness is highly valued. And after the sessions, we move forward. It is not over. It's not to be brought up again, and that's what Judge Battise has also said. We also have contempt in court, which may be revoked, but due to the nature of the proceedings as consensus building, there's usually not an issue as far as contempt. One thing that we do with our courts, and it's big of us to do that, is we go out to the communities. We have a lot of resources to where a lot of our community members do not have transportation. And we have 8 different communities, which I grew up furthest away, which is 88 miles away from the main reservation, which I now live in Pearl, which is the central hub of our community. And we have over 10,000 plus tribal members, with about 65% still living on the reservation. So again, at times they do have transportation problems, and we are able to go out, meet them at a neutral site, maybe at a park or community center, which I believe each community has a community center. We go out there and meet with them and go over their court proceedings with them. Again, there is a security risk there, but you know, one of the judges told me that you can walk outside and a rock or something fall on you. So to be scared to go out there in public, because you see them. I see them every day at Walmart, or if I go to lunch, I'll see somebody that went to court, and you know, they're more or less courteous. They'll come up and just say, Judge, I'm following what you said, and I'm going to continue on. I'm going to show you that I'm going to go be a good person on it. And I said, that's great, you know, good to hear. You know, so sometimes they want to come and talk. It's not more or less to tell you you're a bad person. You know, we got a lot of people in the community that say that, but if we didn't have courts, you know, you would still be out there committing havoc all over. So I try to emphasize that, you know, courts are good, you know, and then Peacemaker is a really great because, earlier I said that it's a win-win situation because we know that our tribal members, within 2 to 3 days, if there's a battery or assault on each other, they're going to be back together. So let the courts, as far as Peacemaker courts, handle that, because if you don't go through this process and it doesn't work out, you're going to go back to the formal court, where the formal court's going to have someone either be jailed for a certain amount of time, or be probation, or no contact during this time. You know, so it's valuable that, you know, you take the opportunity to take peacemaking as a win-win situation, and most of our tribal members do. We've had many. I've heard the co-presenters talk about some forget about coming to court. We make sure that when they leave, that they come to court, because we can work with them, but if they choose not to come back, because it's sometimes when they transfer to court, it's a way to get out of jail, because that day they were going to jail and there was no ands and buts about it. They were going to jail unless they agreed to go to people. And it's not forceful, but, you know, the attorneys who work with them say, you know, this is what's going to help you out. You know, if, you know, I'm trying to do the best I can with you, but I've got people who saw you do everything. So it's really against you, but I'm trying to work with you and trying to let you know the peacemaking court, and she agrees to it, then we can go there and you can be out of jail today, but you got to work with, you know, the peacemaking as far as policies, as far as being out of jail. And it does work out really well. We do have them that forget sometimes. I know somebody said we send our bailiff out there. I don't think we send a bailiff. We send law enforcement to go get them, you know, because like I say, it's very important. We want to be on the same lines as county court, because I don't think you forget about county court. And so we want to be on the same lines that we are a true court. We're not a kangaroo court. I know we've called that in the past, our courts, but again, I guess we're doing something right if we're a model court. And there's not that many courts in Indian country that can say you're a model court. There's something that we've done to where we establish ourselves as a court of Indian country. So we take that highly, and I applaud all of our judges and our staff who made it to where we have been looked on as a model court. Other than that, I don't have anything else to say, but I thank you for coming out and participating with us, and hopefully, you know, I've learned a lot from my co-presenters as far as things that I can take back, and I know we've worked with Peacemaker Battise in the past, and she's come to our annual conferences to talk about Peacemakers, so we have that valuable collaboration. And with my job, I've worked with the Chief Justice of Mississippi, and we have a good collaboration, working relationship with them. And every year, this is our 4th year, which was in August, where we had our 4th annual statewide ICWA conference. And we're one of the main states that's really pushing for 100% compliance with ICWA. And right now, we're getting to that point, and I know we have new judges, different people coming along each year, so we try to go out and educate them. We're also brought out to the state conferences to talk about the Indian Child Welfare Act, and usually myself or we have colleagues that go out there and give presentations on behalf. But again, we've worked well. I know. I hope we continue this, and I hope there was some valuable stuff that myself and our co-presenters have given you to think about. And with that, I'm open for questions. Yes, sir.
Before I ask my question, I can relate to that anniversary and birthday thing.
Okay.
My question is, and I don't know if it really applies or not, but if the two parties that are in dispute and are in what you call formal court are referred to peacemaking court, and during the course of the session, one party admits to liability, we'll say, I don't know, or guilt or some such thing as that. And for one reason or another, things break down and they got to go back to formal court. How is the admissibility of those statements handled when they get back to formal court?
Just like Peacemaker, Battise said, you know, we do not send out what happened in the courts. We only generate a resolution that this is what we're going to work with, this is what we agree on. There's no setting that I did this. And to me, when they come into court, it's more or less working with them because he knew he did it or she did it, to where it's more or less that forgiveness. I forgive you for what you've done. And if there's no resolution, all is sent on in our order, we send up no resolution was generated in court number so and so, so and so. So there's no record. And so once it goes back, there's no indication if there was a admittance to what happened.
But I can foresee that one party is going to say that the other party said, you admitted the light was green. Now you're saying it's red. There's got to be some sort of issue there. I would think after so many cases that would come.
And I guess that's where we let, I guess, the judge that's presiding over that see if it's admissible as far as to put in there. But what is said in the peacemaking court does not leave there.
Okay.
And I'd say, Judge Battise, have anything?
No. In the event that we have to mitigate a case into civil court, our case goes with them. The whole case goes with them. And our tribal members know that once a case is transferred into civil court, it is enforceable. So they do their best to resolve their issue in peacemaking.
Any other questions? If not, we're going to be 12 minutes early. I don't know if Nikki wants. Nikki, do you have anything?
I don't. We can go early. And then just a reminder that we're going to reconvene tomorrow morning and have a morning plenary in the same session, the same rooms that we were in this morning at 8:30.
All right.
We'll just meet tomorrow.
Okay, thank you.